So the San Francisco Law Library is open to anyone. We have books and free access to databases, including those on bankruptcy and student loans to help you conduct legal research. And we are very happy to introduce today's topic and speaker. Here to present on navigating bankruptcy in the new era is Selwyn Whitehead. Welcome, Selwyn.
Thank you so much, Aaron. It's my pleasure to be with you again. So let's just get right into this. We're going to if you could go to the next slide, please.
Yeah, please bear with me as I'm not,
Oh, yeah.
because I'm juggling a few things trying to.
Oh, I'm so sorry.
Okay, there.
Yeah. And on to the next one. Aaron already
Okay.
did this. So the program objectives is to have you have at least a baseline understanding of the life cycle of a bankruptcy case from petition to discharge and identify the key decision points for the debtor and his or her creditors. And then finally, give you an update, well, an overview of the student loan discharge process in bankruptcy and any updates that have taken place this year. Next slide, please. Okay, so let's start with bankruptcy. Next, please. So, what we're going to do here is discuss the bankruptcy code because it's the primary source of bankruptcy law in the United States. Of course, the fundamental law of bankruptcy is our United States Constitution, Article 1. There is a statement in there that says that Congress has the power to come up with uniform laws concerning bankruptcy, because as before we became United States, each individual state had their own bankruptcy laws or insolvency laws. And so the Constitution enveloped them on a federal level. But so the bankruptcy code is a creature of Congress, and it identifies the relationships between the entities that are involved in the bankruptcy process. Um, so the commonly used chapters for individuals and small businesses, because there are more chapters. For example, there's a chapter that deals with units of states, municipalities. But the ones where we're concerned about having access to the discharge are for individuals and maybe small business owners who are sole proprietors. So the chapters are Chapter 11s, Chapter 11 subchapter 5s, Chapter 12s for farmers and fisher persons, and Chapter 13s for individuals with regular income. In addition to the bankruptcy code, there are also federal rules of bankruptcy procedures, which are developed by the Supreme Court of the United States, and those are the rules of the road, as it were. The goal of bankruptcy is to allow for a fresh financial start for honest debtors who find themselves so overwhelmed with debt that it just ruins their life and their inability to make a contribution to our society. But it also is concerned with the equitable distribution of the debtor's non-exempt assets to its creditors on a priority scheme that's been developed by Congress. And a good place for people who are interested in understanding bankruptcy and its historical context and how it's used today are documents created by the CRS. That's the Congressional Research Service. They are the research arm of Congress. They produce really great publications on bankruptcy, student loan debts in bankruptcy. So I indicated the link there. Um, so I can send this to individuals who want it, but it has some really great the CRS they have some really great publications that I heartily recommend. Next slide, please. So for bankruptcy, on a high level, businesses and individuals with regular income, there are debt limits for filing a Chapter 13. Currently, you can have a little bit more than 1.5 million in secured debt and a little bit more than $500,000 in unsecured debt. If you have more debt than that, you need to look at filing a Chapter 11 or working with your counsel to look at alternate ways to deal with your debt situation. So in a Chapter 11 or 13, the goal is to reorganize your debt. It's a way to give you time to, say, catch up on your mortgage that got into arrears because you were ill. And generally, you have between 3 to 5 years. If you do a Chapter 11, that can be pushed out and expanded to maybe 10 years or even 15 years. But most individuals want to file a Chapter 13, and there are debt limits. You need to know that yeah, your mortgage, your first mortgage, it's kind of inviolate, and you have to figure out a way to deal with that, or your first mortgage holder can figure out a way to take your property from you, notwithstanding the fact that you file for bankruptcy. They'll file a motion to have the stay lifted if you're not. For example, you might owe $30,000 worth of arrearages, but when you file for bankruptcy, you got to get current right away going forward. So you can spread the arrearages over the course of your bankruptcy. But if you get behind in making your payments, you're going to find yourself in deep doo-doo, as we like to say in the neighborhood. So I just pointed that out to you because the lender can still foreclose if you've failed to timely pay your secured debt as of the date of the filing of the bankruptcy. Again, you can use the bankruptcy to catch up with the arrearages and put those over time. But if you say, for example, some people don't realize if you do a reorganization, you have to have a source of income. And I spend a lot of time educating people that if you don't have a regular source of income, you don't meet the criteria for a reorganization, be your the entity that's filing a small business or an individual with regular income, or a fisher person with regular income, or a farmer with regular income. Okay. So that's for a chapter, a reorganization, a Chapter 11 or 13. For a Chapter 7, you have to pass a means test because you're looking for people who tend to want to abuse the process. Excuse the noise in the background. That's the annual test that they do up here for making sure that we know if a fire is up here. Liquidation of a Chapter 7 gives you the ability to liquidate all your non-exempt assets, non-exempt assets. So exemptable assets are those that, notwithstanding you're in bankruptcy and you want to liquidate, the code and Congress knows that you need to have a baseline to be able to continue your living. For example, if you have an automobile, and I'm just making these numbers up, it might have a value of $15,000, and the exemption might be for $7,000. So that means 7,000 of the $15,000 is reserved for you. And if the Chapter 7 trustee believes they can sell that automobile for $15,000, your unsecured creditors will get the delta between the $15,000 that it's sold for, but you get to reserve the exemption. Okay? So I just want to point that out to you. Notwithstanding the exemptions and what have you, if you have a mortgage, you need to figure out a way to make your mortgage current, okay? Because you're in a 7, you're not reorganizing, you're trying to get rid of as much debt as possible. Next slide, please. So the key filing issues, some people don't believe it, but you can discharge taxes in bankruptcy, but they must be old, they must be seasoned. And there's steps that you have to assure your client has met in order to discharge those taxes. So it has to be properly seasoned. They actually filed a tax return. They timely filed a tax return, and it happened as far enough away from the filing to be seasoned. So if you're going to be helping your clients, if you're an attorney, you need to know these things because you have a duty of competence about these areas, or you need to find someone who can help you. And there's also the possibility of a financial institution offsetting your debt that you owe to them. So counsel needs to make sure that any offset is properly conducted. And some banks, like in the old days anyway, used to like to freeze your account until they got permission from the trustee to unfreeze your account. So we'll just think you're already in financial distress. You need your money to, show that, you have the ability to keep going, and then a bank freezes your account. That's a pain in the behind. So you need to deal with that. Also, some credit unions have pushed the theory that they're entitled to um, uh, um, have the ability to offset or your all of your different kinds of credit union accounts. So you need to make sure if your client has an account with a credit union that they don't abuse your client. Also, HOA dues are a special kind of debt that needs to be given careful consideration. Utilities are another kind of special kind of debt that your client needs to be made aware of. Um, then there's the means test is for both 13 and 7. The idea is that if your debtor has, after they go through these calculations, and it would be better for your debtor from society's point of view for them to be in a Chapter 13 where they continue to attempt to make payments versus a Chapter 7 where they get to liquidate and get rid of their unsecured debt. And then it's okay to do exemption planning. You might want to time the bankruptcy to make sure that you can deal with exemption planning. That is to say, how do you, maybe that the exemption for that automobile example that I gave you is going to increase from $7,000 to $15,000 if you wait 2 months. So you talk that over with your client to make sure they understand. Also, tax planning. If the goal is to get rid of old taxes that aren't quite seasoned, you might want to wait until that seasoning takes place. And for you practitioners, if you know that tax debt is an issue, you want to get a waiver from your client if they insist on moving forward without waiting until the taxes are seasoned. Next slide, please. Okay, so these are the key terms in bankruptcy. The order of relief is the date that the bankruptcy court puts their seal on there and that you filed, and it's the order of relief, putting the whole world on notice that your client or you, if you're an individual, are in bankruptcy. And most financial institutions and creditors are tied into a system where they get notice as soon as their clients file for bankruptcy. One of the most important parts of filing for bankruptcy is the automatic stay that stays most litigation against a debtor as soon as the order of relief is issued. But there are circumstances where the automatic stay will only be in place for a duration, a short duration, or not at all if your client or you are classified as a serial filer. The first time you file for bankruptcy, there's an automatic stay until the court lifts the stay or the case goes away. If you file within a certain period a second time, the automatic stay is only in effect for 30 days. And so during that 30-day period, you have to get in there and explain to the court why it is the debtor's circumstances have changed and why now they should be able to push out the stay for the duration of the second bankruptcy. However, 3 or more times in bankruptcy, you're a serial filer and you need to, there will not be a stay, but you should ask the court to impose a stay if you are under, if you have the right facts and circumstances supporting your debtor. Then the most important thing in bankruptcy from some people's point of view is the discharge. That is discharging you of any further responsibility for a debt that you would otherwise be required to pay. Then there's something for secured debt, bifurcation, and cram down. Bankruptcy is about valuation. It's about tying the value of an asset as of the day of the petition or shortly thereafter to its real value. So, for example, you owe $1 million on a piece of property, but it's only worth $500,000. Some kinds of bankruptcy allow you to bifurcate those two, that one loan into two loans, theoretically, and cram down to the $500,000 valuation. And then you can strip off the lien in chapters 11 and 13. Plan feasibility is crucial. I really have a lot of discussions with potential clients, and sometimes I try to help clients who had their cases converted because they can't show feasibility. If you're going to be in a reorganization bankruptcy, again, your client or you have to show to the court with documentary evidence that you're going to be able to pay the $3,000 a month to the trustee to make your plan payments. Or are you going to be able to produce the $11,000 a month to make your plan payments? It's not that you just get into bankruptcy and then you figure out what to do, because some of these payments have to be commenced within 30 days or 90 days, depending on what it is you have to do. So I tend to want to work with a potential client beforehand to get, information and evidence that I can help educate them on their duties and responsibilities. Because again, you file the bankruptcy, you're not able to show the court that it's feasible, you're going to get booted out, and then you're still in financial distress, and then you're going to want to file again, and then you're only going to have the automatic stay for 30 days. So if we could figure out a way to make sure that you're going to show the court that your plan is feasible, that's crucial in any reorganization plan. Okay, you also can use bankruptcy to reaffirm your automobile, that you reaffirm continuing to make the payment on your automobile because you need it to get to and from work. You can redeem assets, or you can surrender secure assets to your creditors and then not be responsible for paying them anymore. Okay, so things you need to be concerned about is you can't be a badass in bankruptcy. Sometimes being a badass is you have a good reputation, like some of those um, baseball players. They're badass. They hit the ball every time and up into the bleachers. But you don't want to be a bad boy or a bad girl in bankruptcy, because you're going to find that your case is going to be dismissed or the debt will not be dischargeable. Okay? And then if you're really a badass, your discharge could be revoked. So, bankruptcy court is a court in equity. That means the bankruptcy court is looking for the debtor's good faith and your creditor's good faith, and the idea of filing for a reason that comes into fore regarding the bankruptcy code. Next slide, please. So, who are the key players in a bankruptcy? Well, there's the debtor or debtors, because it might be partners or husband and wife, or entities that are jointly filing. Then there's the debtor's creditors, and there's always more than one. There's the debtor's counsel, who has a duty of candor and competence, and to give good advice to their debtor, but also has a duty of candor to the court. So if you're a counsel and your client wants to do things that are untoward, you need to withdraw from their representation. Another key party is the creditor's counsel. Sometimes they have multiple counsels, and if there's multiple debt, they will have multiple counsels. Then there's the bankruptcy court itself. A bankruptcy judge is an Article I judge, a creature of Congress. That's how the bankruptcy code is fashioned. But a bankruptcy court is appended to an Article III court. The bankruptcy judge's staff, who help the judge analyze the case and the parties' issues and help resolve them, adjudicate them. There's the clerk of the bankruptcy court, the chief administrative officer of the bankruptcy court. And then there's the chief judge of the bankruptcy court, the chief executive officer of the bankruptcy court that tries to make sure that all of the judges within a particular court are going in the same direction. If, not they have their freedom to make decisions on their own, but there are some local rules. And so the chief judge of the bankruptcy court works with the judges in the bankruptcy court to come up with local rules and procedures that make sense for all. Another key player that many people don't realize is the Office of the United States Trustee, which is a subunit of the Department of Justice. That office is an auxiliary to the bankruptcy court, and they're charged with preventing fraud, dishonesty, and maintaining the integrity of the bankruptcy court and its process. And the Office of the United States and its lawyers work under the general supervision of the United States Attorney General and the Department of Justice. And then there's different types of trustees depending on the kind of case. Initially, a Chapter 11 individual or Subchapter 5, they act as the debtor in possession. So they're the fiduciary. They're acting as a trustee as long as they, do things according to Hoyle, but they might find themselves replaced by a trustee that's going to be appointed by the court if there's anything kind of hinky going on. Hinky is a highly technical legal term. Next slide, please. So filing considerations, again, you want to make sure that your debtor, or if you're filing yourself, that you are eligible by passing the means test. And individuals have to take a mandatory credit counseling course. You need to review all your assets, determine the appropriate exemptions, and what non-exempt exposure there might be. Because, for example, it breaks my heart when, and I've seen this several times with seniors, they go into financial distress and then they file a Chapter 7 on their own. Well, you file a Chapter 7 and you have substantial equity that you might want to use to get caught up. But if you file a Chapter 7, a Chapter 7 trustee is going to come in and take over, and their sole duty, their fiduciary duty goes to the creditors. And so I sometimes have to come, if afterwards the person hires me to help them, go and explain to the court that we really should have filed a Chapter 13 and asked the court to convert it to a 13, because you would hate to have all or most of the equity absorbed when there was an opportunity in a Chapter 13 to keep that equity while paying some of your creditors. Okay, and again, timing is everything. For example, if you are anticipating an increase in your income and you need that to show feasibility, you might want to file now, explain it to the court, get an extension of time to show that your plan is feasible. So go on to the next slide, please. Okay, then once you file for bankruptcy, there is a state is created. And I make this terrible joke, and I'm just going to share it with you because you're captive audience. I also do probate wills and trusts. And I make the distinction that people who come to me for probate work, they or their family know that they're dead. In bankruptcy, the client doesn't know that their finances are sometimes dead, and it's our job to try to bring them back to life. Excuse me, I have a terrible sense of humor. Okay, so then because there's an estate, there will be appointed a trustee, and the trustee is there to help the debtor administer the estate if it's a reorganization, bankruptcy, or administer the estate even if the debtor is there, if it's a liquidating bankruptcy. So, and you also have to know the difference between estate property, which is that non-exempt property versus exempt property. And a trustee has the ability to pull back assets that the debtor might have disposed of on the eve of bankruptcy, demanding turnover of assets from the debtor's friends and family, take an avoidance action if the debtor has given property away, transferred property via deed. The trustee has the ability to avoid and also cash collateral is an issue that comes up. So that would be like rents. That's the cash collateral of the entity that holds a security interest on the debt. Next slide, please. So the milestones and deadlines in bankruptcy, if it's a Chapter 11, there's an initial debtor interview that takes place within 30 or 45 days of the filing, where the Department of Justice, the U.S. trustee that I talked about, interviews the debtor to feel out and make sure things are according to Hoyle. Then generally within 45 to 60 days, there's a meeting of the creditors. That's where the debtors' petitions and schedules are reviewed by the trustee under oath, and to make sure that the information provided is accurate. And so that means that counsel has to prepare the debtor for that meeting of creditors. And creditors can show up and ask questions. So you want your client to be prepared for that. Also, another thing is the trustee will sometimes object to the exemptions that you're taking. And there are also deadlines for creditors to, object to the debtor getting a discharge or dischargeability deadlines. And so dischargeability, that litigation, we're going to talk about that because that's crucial in student loan debt. And then another crucial date is if you're doing a reorganization, you have to file a plan and you have to get it confirmed within a certain timeline. Next slide, please. So, yeah, the creditors are involved. They file proofs of claims, even for secured debt, especially if the secured debt also has some arrearages attached. So they have to file proofs of claims by the bar date. They also can demand adequate protection, that is get an order from the court explaining what the debtor has to do in order to continue to use the creditor's cash collateral. For example, that would be in a situation where there's income producing property that technically belongs to the secured creditor. And so the debtor might need that in order to pay the mortgage. And so all of this is spelled out so everybody knows what's going on. And if they're not able to get adequate protection, or sometimes even if they do, the creditor will ask the court to lift the stay so they can continue to go on with a foreclosure. And also creditors involved in negotiation and settlement opportunities. Next slide, please. So the debtor has risks and duties and responsibilities. They have to disclose all of their assets, liabilities, income, and expenses. Someone said something really bizarre to me one time. Well, I really like that credit card company, so I'm not going to put that credit card company in the bankruptcy. I says, well, no, it kind of doesn't work like that. You have to list all your assets, all your liabilities, your income and expenses, and the consequences for not doing so, especially when we're talking about assets. You have an asset, you have some property over in the United Kingdom. Well, that's out of the country, so that really doesn't count. You have to, no matter where your assets are, no matter how you produce your income, you have to disclose. You should over disclose. Then you have duties for post-petition, financial conduct and reporting requirements for especially Chapter 11s, including Subchapter 5s, where you have to do monthly operating reports to show that your plan is or will be feasible. And not doing that can end up in having your case dismissed or discharged or having other sanctions placed on you. Next slide, please. So now let's get into the student loan debt. Next slide, please. So the purpose here is to do an introduction and the goals, to scope out and share with you the limits of the Department of Justice, Department of Education guideline, the framework for getting your student loan debt discharged is the Bruner test. And there's a process that you can use to engage the Department of Justice in this application process, and that is via an attestation and with a goal of having a stipulation filed on behalf of the debtor and the Department of Justice, who's representing the Department of Education for federal student loan debt. So we can go on to the next. So the goal of the change in how one goes about proving that they should be eligible for a student loan discharge. So in 2022, under the previous administration, there was the goal towards how do we make bankruptcy student loan discharge clearer, consistent, and reduce the debtor's burden, and increase the possibility of having stipulations between the Department of Justice on behalf of the Department of Education and the debtor, so the debtor can get on with her life. Next slide, please. So you should know that the 1978 version of the bankruptcy code listed two ways that a debt could be discharged. The debtor had to show an undue hardship, or the debt was at least, the student loan debt was created greater than 5 years ago, and the debtor was making payments for at least 5 years. Later amendments removed that 5-year option. So now undue hardship used to mean that there was a certainty of hopelessness. It was really hard to get student loan debt discharged. In fact, between 2011 and 2019, 99.9% of bankrupt borrowers didn't obtain a discharge, and a lot of that was because they didn't even try, because the word on the street was it was impossible. So let's go on to the next slide. So on November 22nd, the Department of Justice and the Department of Education released the guidance to streamline the student loan debt discharge in bankruptcy. It was designed to make the process more transparent, fair, and accessible. And I cite there the actual guidance. And if you'd like a copy of it, I can send that to you. Or yeah. So go on to the next page. And it's, again, designed to reach a settlement. It's not binding if the case doesn't settle. It does not create an enforceable right for the debtor. It applies when the Department of Education is the holder or the guarantor of the student loan. And it was initially believed that it would likely expand to other types of loans, including private lenders, but the new administration seems to be going in another direction. So let's go on to the next slide, please. So it's prospective in application. It applies to cases that are still pending since 2022 and future cases, and it's applicable in Chapter 7 and 13. Next slide, please. So the framework applies the 3-part Bruner test, and the Department of Justice will evaluate the debtor's present, future, and past circumstances, and may also consider a partial discharge. So go on to the next. So Bruner test part 1 looks at the debtor's present circumstances. The debtor must prove an inability to maintain even a minimal standard of living if they're required to pay their federal student loan debt. And how the machinations is you use the IRS's collection standard for allowable expenses. And it sets caps and debtor limits to actual expenses. And then other necessary expenses might be considered. So those are going to be, you have surgery next year, or your dependent has to have surgery next year. You can inculcate those anticipated expenses into determining what your available income for paying your debt is. Next slide, please. So, so that's present circumstance. So it's income comparison, compare income to expenses. Gross income includes Social Security and unemployment. And then if your expenses exceed your income, that element is satisfied. However, if you have some ability to pay, you and the Department of Justice might want to put before the bankruptcy judge a partial discharge of your student loan debt. And that's just a slide showing, as of a certain date, you look at your food, housekeeping, apparel, personal care, miscellaneous total. And so that's how you determine what is an appropriate expense to take away from your income for these purposes. Next slide. And then the next burner part 2 is the future circumstances. The dilemma that you define yourself in right now is persistent. There's a rebuttable presumption that your financial situation will continue as it is if you're 65 or older and have a disability or some kind of chronic illness. If you've been unemployed for 5 of the last 10 years, you borrowed this money and you went to school, but you didn't get a degree. The loan is in payment status for at least 10 years, for more than 10 years. So the rebuttal the entity that's refuting or that your financial situation is persistent has to come up with, fact-based rationale for rebutting it. So if no presumption, then your client or you as the debtor may put together a declaration attesting to the facts showing your future instability. And then past circumstances looks at how have you conducted yourself with your student loan debt creditor. And it has to be that you made a good faith attempt to pay these debts, but you just were not able to. Go on to the next. So assets and partial discharge. So it might just be that you're paper rich, but these are assets that are very difficult to, or it might even be impossible to liquidate. You're a good debtor. You've identified assets that might be illiquid, and they also might be, in another country, or there might be some kind of impediment from you liquidating them. So that just might be the case that you would get a partial discharge, or if you could prove that the asset is totally illiquid, it might just show that you do not have the ability to make the payments. Next. So there's an attestation form and a litigation report. Upon filing the adversary proceedings, so you file for bankruptcy, and then inside the bankruptcy, you initiate a federal lawsuit against your creditor, the Department of Education, that's going to be represented by the Department of Justice. And then based on that, the Department of Education will produce a report showing the facts surrounding the debt, how much debt is owed, and the track record of the debtor while they were. And you also get to use that information in preparing the attestation where you identify facts for the court. So the Department of Education provides the assistant U.S. attorney and the debtor with that account history, loan details. That's the litigation report. The assistant U.S. attorney submits a settlement recommendation to its client, the Department of Education, and also to the local Department of Justice attorney that's going to be handling the case. And if the matter settles, the parties present a consent judgment to the bankruptcy court, and more than likely the court will go along with it. So that's the easy way to deal with it. Next. Okay, so let's look at the process at a glance. The debtor completes the attestation form. The DOJ applies the present ability, future ability, and good faith factors to it. The Department of Justice will recommend a full discharge where appropriate and consider a partial discharge, but the bankruptcy court, as the final arbiter, will make the final decision. Next, please. So again, this is special kind of federal lawsuit inside the bankruptcy, the adversary proceeding. It requires this separate adversary proceeding with the claim being the debtor has an undue hardship. And the goal of the Department of Justice and the Department of Education is to promote transparency, reduce burden, aid in identification, and the appropriateness of a discharge. Next, please. So here's some information. On that short period since this process started in 2022, 70% of the time, the Department of Justice recommends full discharge. Another 15% of the time, the Department of Justice has recommended partial discharge. So that's 85%. So it went from 99.9% between 11 and 19, being SOL about getting your student loan debt dealt with, to 85% full and partial recommendation from the Department of Justice. And as it says here, courts have accepted the recommendation of the parties in 98% of the time. So there's my source material. So let's go on to the next slide. So this is a big issue for us as a society. 43 million borrowers, and a lot of them are seniors. That is 1 in 6 adults hold $1.6 trillion in federal student loan debt. So this is an escalating problem. My source is located, stated there. And so the rest of these slides are about, keep clicking through, Aaron. I think these are just my, okay, so let's go for chapter 13 again. Okay, so there's local rules that bankruptcy courts have set up to help debtors and their counsels go through this adversarial procedure process. But there's some issues. Especially that last one, how are attorneys going to get paid? And that needs to be fully discussed with your client, and you as a lawyer need to do the research necessary to find out how it might be, how you will get paid. Okay, go on to the next slide. So this is just a visual. So again, you file the AP, you get the attestation request, an opportunity to move ahead. The Department of Education produces the litigation report to the USA and the debtor and the assistant U.S. attorney / education department. And then you follow any local rules that might have been developed in the bankruptcy court where you're filing your case. And if everybody approves, you get a consent judgment and you settle, and then it's put on the docket, and your client, or if you're doing it yourself, you walk away happy. Next slide, please. Again, the Northern District of California has procedural guidelines that were developed by one of our great bankruptcy judges, and it's the Bruner test and the Pena test, which is a Ninth Circuit case that lays out the steps that you have to take to go through this process. Next. Again, more background material, so we can just go to the next slide, I think. Okay, so summary. You have to act in good faith to be in bankruptcy in the first place. But then there's an additional burden that you've acted in good faith as far as dealing with your student loan debt. You made your payments as best you could. You looked at deferment or forbearance processes. If your debtor or your client was not in good grace, you look at application for any kind of reduction in payment, including those that are based on your income. You might want to consider federal consolidation application as opposed to consolidating your federal debt with your private debt, because that opens up a can of worms where you might be reducing or eliminating some of your protections, and you might be opening up additional statutes of limitation. So we're talking federal to federal when you're looking at consolidation. That's what I'm talking about here. Um, you've Additional ways to show that you're acting in good faith is you responded to the servicer of your federal student loan debt and you communicated with them, trying to show that you're acting in good faith because you are, and you engaged in meaningful dialogue uh, with any kind of educational servicer or any kind of legitimate third party assistance. Note that enrollment in an income-based payment program is not controlling if the debtor can explain why they did not want to engage in that or could not engage in that income-based. So income-based means that your payment would be reduced to the amount that you could show that you could pay based on your income at the time you go into financial distress. So, but that is not a bar. If you didn't agree to that, that's not a bar to utilize in the program that was set up by the previous administration. Next slide, please. Again, this is just showing the presumption of persistence. You're an older person, such as me, or you have a disability, chronic illness. You've been unemployed for 5 of the last 10 years. You borrowed this money, you went to school, and you don't have a degree, and you were in payment status for at least 10 years or more. Next. Present ability assessment, you use the IRS allowable expenses, compare your gross income, including Social Security and unemployment, against your expenses. Next. The attestation form can be a bear. So I've just broken it down. There's personal information section, current income and expenses, again, based on the IRS collection standards. And also, since you filed for bankruptcy, your schedule I and J, that's your income and expenses. That's where you can get some good information. Your future inability to pay, that's a presumption and other facts. And then prior efforts, that's your good faith, your current assets, if they are liquidable, and sometimes them not being liquidable is an issue, and additional circumstances that, you want to put it all on the table. You want to, if you're representing the debtor who wants to discharge, you want to put their best foot forward, honest best foot forward. And if you're representing yourself, you need to come up with all the additional circumstances, facts and circumstances that can show the bankruptcy court that you are an excellent candidate for having your student loan debt discharged. Next, please. So gather the documentation early. I am really retentive. I want to see my clients' income and expenses, including their medical expenses and their employment history, so I can help them, think through this before we file for bankruptcy. Again, using the IRS standards to structure an appropriate budget, detail our good faith efforts and the reasons why we didn't do an income-based payment reduction and enroll in it, and identify the reasonable, unincurred, but expected to be incurred expenses, such needed care for yourself, your spouse, your child, or your automobile is 25 years old and it's falling apart. So, use logic to help your client articulate these potential expenses or known expenses, but have not yet incurred. Next slide, please. So let's look at bankruptcy in its macro. It's a fresh start for the debtor, and it gives your creditors a fair return based on their class. The automatic stay bars collection activity upon filing, And the goal is to get a discharge. And a discharge means you're not responsible for the debt. So student loan debt can go into that class of dischargeable debt and can be discharged at the conclusion of your bankruptcy if we can show undue hardship. And that's the specific code section of the bankruptcy code that talks about these issues. Next, please. Okay, so more sources. Next. So let's talk about the landscape in 2025. Again, we're talking about federal student loan debt and private debt. The distinction matters. It's conducted in an adversarial proceeding alleging that the debt is dischargeable because of the debtor's undue hardship. The relevant standard is evolving. Next slide, please. So, undue hardship, administrative process, evidentiary considerations. Next slide, please. Private student loan debt, it just might be that it could be discharged because they don't have the added protection of our federal government. So it's based on contract law and state law defenses. There's some noise in the background. I think somebody needs to put it. Okay. And then the settlement dynamics are those of a private lender. Next slide, please. Okay, so we've already gone through this. So here, practical implications for 2025. What's changed in 2025 and how it integrates into the court strategy? So all I can say is there's a new administration with different views and goals as far as student loan debt is concerned. For example, the current administration is shutting down the Department of Education. So who are you going to talk to? And it's in the process of transferring the DOE's student loan debt monitoring and collection processes to the Department of the Treasury or to the SBA. There's going to be fewer options for public service loan forgiveness. Before, there was a whole class of people who got into financial distress over their student loan debt. They could, by working directly with the federal government, have their student loan debt go away. They're fire persons. They're doctors who work in community hospitals. There are lawyers who work for nonprofit organizations. Unfortunately, the current administration seems to be interested in removing the nonprofit status from hospitals. So what's that going to mean for nurses and doctors who work for those hospitals and did so knowing that they were going to devote 10 to 20 years of their life to this nonprofit in exchange for having the government help them get a medical education or a lawyer do likewise. And in fact, just today or yesterday, the current administration has changed the public service student loan program to eliminate those kind of nonprofits that the administration doesn't think is appropriate. So, and also the current administration is looking at doing away with the tax-free loan forgiveness and student loan interest rate deduction. So I'm just sharing these things with you because your duty of competence is to know how to help your client inside of bankruptcy, but also outside of bankruptcy. Next slide, please. So litigation, it's like federal litigation, pleadings and proofs and discovery and expert use. Generally, these things are taken care of in a summary judgment kind of mode. And then you have to understand who is going to be responsible for paying the attorney's fees. Next. So again, ethics and professional responsibility. If you're going to assist people with student loan debt, you have a duty to be competent. You have to know about conflicts and fee arrangements. And then again, you have that duty of candor with the court while protecting your client's confidentiality, where if you find out something is untoward, you might just need to withdraw under court supervision. Next slide, please. So I prepared a checklist that I use to help me, and I also have a matrix that I use to help me. But the goal is to negotiate with the feds to try to get this student loan debt to go away. Next slide, please. Again, the San Francisco Law Library has wonderful resources that are free to attorneys and pro se litigants themselves. So I'm going to turn it back over to you, Aaron. I'm sorry I ran out of time, big mouth.
No, thank you so much. So anyone, please put your questions in the chat, everyone. And anyone questions? So give it a minute here, and I'll just go over a little bit of reminder on the some of the administrative side. Can you hear me? Okay, I unmuted myself. All right.
I can hear you.
Okay. Okay. Great. So, and thank you again so much, Selwyn.
My pleasure.
Uh, so we'll send certificates within give us 3 business days. Uh, and let's see. Yeah, and that's all I have on this. We should have gotten the an outline also with the email I sent today, but if you didn't, please send us an email us at SF Law Library.
I just
Um,
want to say thank you,
um,
Michael. I appreciate their comment. Take care.
thanks. And so yes, thank you. Got a nice thank you in the chat. Don't see any other questions here. So I guess with let me just give that another quick minute. And again, also what I didn't mention is if you this indicated you're a paralegal, then I'll go ahead and send you a letter stating the amount of time that you show as being in the program up to 1 hour, 60 minutes. And any other questions? Okay, I don't see any questions then. So if you missed any parts of this, there should be a recording up. Uh, if you want to check them out again, there should be a recording up within, usually takes a few weeks, so you can get it by then. Remember, we have a lot of free resources here at the San Francisco Law Library, free Westlaw, Lexis, Bloomberg Law. And so come in and check out our resources. And at that point, I'll just go ahead and wish everyone, especially Selwyn, to have a wonderful day. And thank you for joining us.
Take care, everybody. Bye bye.